Hi guys, Ron Rohde from Ronald Rohde Law. Welcome to another video walkthrough with ACRE. Today we're going to be discussing anchor leasing. We have a great template form for you to download, and we'll discuss the nuances of analyzing this type of property. Anchor leasing is very unique in that the anchor tenant, typically a large grocery chain like Wegmans or Whole Foods, retail like Best Buy or Target, they have an unparalleled amount of leverage during lease negotiation as well as during the life of the lease. Today we're excited to have Tim Donovan, who is an anchor leasing expert from the DC area. Tim, can you introduce yourself?
I worked in development right out of college with a developer out of Baltimore who does a lot of mixed-use development, does some casino work, office, retail, shopping center, grocery anchored, kind of a very wide-ranging asset class. I worked there and I did some property management, I did leasing, and I did development. While I was doing that, I started in law school in the evening, subsequently moved to a second developer and finished law school in the evening. Since then, I've worked at two firms. I worked for Miles and Stockbridge in DC, and now I'm at Nelson Mullins, also in DC. Nelson Mullins is Southeast based. We're based out of Columbia, South Carolina, with 25 offices nationwide. So, pretty wide ranging group of attorneys. And now I kind of dabble in all different asset classes. I do a lot of affordable work. I do a lot of leasing. I do a lot of financing as well. And then some deal structuring. So operating agreements and waterfall provisions and kind of more on the owner side rather than the investor side. But it's a pretty wide ranging practice, which, I prefer.
Let's talk a little bit today about this anchor tenant. You've put a lot of effort and energy into this sample lease, and I know that it can't cover every single facet or every possible scenario, but let's talk about who could use this or who's going to benefit from our time today.
So generally speaking, when you're doing an anchor lease, the lease itself is going to be on the anchor tenant's form. And the reason behind that is you have, these very large tenants who do lots of deals throughout the year. And from a logistics standpoint, it's much easier for the tenant to negotiate these leases when they're comfortable with the form. Ideally, that's not the case, but generally speaking, tenants have their own form. That is certainly not the case for smaller tenants, where landlords have much more leverage to put these leasing agreements on their own form. But generally speaking, you're on the tenant's form. And really, as you mentioned before, the leverage and the negotiating position of the two parties, landlord and tenant, is heavily skewed towards the tenant. And the biggest reason for that is the fact that an anchor tenant can make your project. If you have a good anchor tenant, then the value of the adjacent spaces increases. If you don't have a good anchor tenant that isn't driving sales, that isn't driving foot traffic, that makes it harder for smaller tenants to have synergy. So this lease form, while on the rare occasion a landlord may be able to use it, a property owner may be able to use it, this is really to understand certain provisions that most anchor tenants will require and potential strategies, things to think about, and just creating a general understanding for these provisions prior to looking at it for the first time. In addition to that, if you have an owner who's trying to purchase a property with an anchor tenant, there are certain provisions that we'll talk about that should be noted. And it's very important to understand where a tenant may have a termination right, where a tenant may have the ability to decrease their rent, the ability to shut down their operations, and numerous other things like that. But generally speaking, this can be used by landlords, but will be tough to force an anchor tenant to use the form. But it's really a way to understand these provisions prior to looking at a new lease or looking at an existing lease and trying to understand the risks associated with that particular tenant.
So just give me some ballpark. I mean, I don't know if these are your clients or adverse, but like obviously the Targets, the Walmarts, they're going to have their own form lease. That's fine. How small are we talking in terms of a regional? I mean, it's going to be like Piggly Wiggly still has their same form. Is it going to be something, smaller? Is it going to be in Texas, we have like a Texas Family Fitness. They've got 50 locations in the state of Texas. Are they still going to have their own template form, or what size does it have to be a 30-year-old shopping center?
What I would say is most of it depends on kind of two factors: the square footage of the tenant and the number of locations. And again, this is by no means a hard and fast rule. If you're a single property owner, it's harder for you to have a form lease. And in this situation, I think the form lease that we put together would be helpful. But if you are a large property owner that owns numerous shopping centers, grocery anchored, power centers, whatever it is, then you have the legitimacy, you have the backing, and you can go into these negotiations and try to push for your form. Again, a Giant Food, a Wegmans, a Walmart, whatever it is. If it's a large tenant with multiple locations, if it's a publicly traded tenant, absolutely, you're going to have a form lease that they are going to use. And a lot of it is how quickly these tenants have expanded. So if you have a tenant who's doing 2 deals a year, there's probably a better chance that they have a form lease simply from a time standpoint. But if you're looking at a tenant who's doing 10 or 15 deals a year, sometimes there's just not enough time. So, it really varies, but the names that someone would know, the big names that people would know, will have their own form lease.
Well, let's just jump into it. I can pull up and look at this lease with you.
The first one that we can jump to is section 1N, which is on page 2 of the document itself. It's titled Tenant Mix. It's a good starting point to kind of talk about a big theme of these anchor leases. Because at the end of the day, a landlord doesn't want to restrict its ability to operate its property. Mm-hmm. If I want to lease to whatever tenant, I want to be able to do it. And I want to be able to put that tenant wherever I want. I want that tenant to pay the rent that is market in the area. And it's my shopping center, and that's what I should be able to do. However, there are a lot of provisions here that kind of fall into one of two buckets. One is the tenant restricting the landlord's ability to do something. And number 2 is the timeframes in which certain obligations have to be done, things have to be built, things have to be completed. And in the event of a failure to meet those timeframes, what the penalty is for the landlord, for the tenant, or whomever that is. But those are really the 2 big buckets that you want to limit in every lease as a landlord. But from an anchor tenant leasing perspective, those are the big 2 that I really try to focus on. Because at the end of the day, you want to have minimal restrictions on your client as the landlord. And you want to get to a position where you're comfortable with what those provisions are. You're comfortable with what you can and cannot do. And you try to make those provisions as clear as possible so there's no ambiguity to the extent something happens that may or may not trigger that event. So to start with tenant mix, it's a perfect example. This provision essentially provides that the landlord will only lease to certain types of uses. And that is done from the anchor tenant's perspective solely because these tenants come in and they know the tenant mix that helps them maximize sales. So if you have a sporting goods store, it would be great to have a fitness use. If you're a sporting goods store, you don't want to have a lot of office in a property. So there are certain uses that anchor tenants know that are helpful to them. And this provision really walks through that. There's a lot of variability for this, but just looking through it, it just expressly says landlords shall lease to the following types of uses. So again, a restriction on use, a restriction on the ability to operate your property. Now, the list of uses may be very extensive. So that provision, if negotiated correctly and if agreed upon by the tenant, may not be overly restrictive from a practical perspective. But if there's a use in there that you have a potential tenant and you can't lease to them, then you're in a position to go to your anchor tenant and ask. And if you don't, then there's potential penalties associated with that.
Again, this exclusive uses are not unknown to just a regular generic retail lease. The difference, I think, is really the scope and the detail. And as a landlord, you really have to think about it ahead of time. You've got to really plan out how this building is, or how this center is going to get leased up, because you can't just do it piecemeal, take them one tenant at a time. It's really a holistic approach that, again, I think is different for landlords. If they're struggling, if they're delayed, or they're not getting as much occupancy. They may have a balloon note coming due. They're kind of desperate to be able to refinance and they need some better occupancy. This is where you get pinched between a rock and a hard place, trying to put tenants in, squeeze tenants in that don't fit. Can you tell us a little bit about co-tenancy and, you know, people are looking for a certain percentage. What other concerns can you negotiate in the co-tenancy?
Sure. So as a general matter, the co-tenancy provision provides one of two things, and two things have to be satisfied prior to this being triggered. So number one, there has to be some sort of percentage of occupancy or vacancy, or, you know, certain tenants have to be operating, certain tenants need to have opened, or, you know, again, the possibilities are pretty extensive, but, you know, let's just assume we're talking about a shopping center that's 100,000 square feet and we're negotiating with a 40,000 square foot tenant. So of the remaining 60,000 square feet, the anchor tenant may say, okay, well, we have to have 50% occupancy. And obviously, for obvious reasons, you want foot traffic, you want synergy, you don't want a dark shopping center. It doesn't really make it appealing for a customer to come up unless the use for the anchor tenant is a necessity. But generally speaking, you don't want a dark shopping center. You don't want a vacant shopping center, and neither do tenants. So they would negotiate that at all times there has to be at least 50% occupancy of the square footage, except for the anchor tenant. So of the 60,000, 30,000 has to be occupied. If that is triggered, if you drop below that 50%, then there is a lower rent payment similar to the exclusive use generally that's triggered, and that which would follow a specific amount of time in which that co-tenancy would continue. That failure of the co-tenancy would continue. So if you're under 50%, if you're at 45% occupancy of that 60,000 for a period of 6 months, 9 months, 12 months, 3 months, whatever it is, after that time frame, then there would be a lower rent that would kick in. When COVID kind of first started and quarantines were issued and stay-at-home orders, and, you know, only necessary tenants were allowed to open. You had the grocery stores open, you had liquor stores, you had, you know, only a few types of tenants that could open. You could have a dark shopping center. So, you know, you never know, and you have to determine what open and operating means and what occupancy means. So you're not triggering these provisions, because generally with a co-tenancy provision, there is some sort of penalty. And, you know, in the lease, in the form lease, the way it's drafted is the landlord would provide a payment of tenants' unamortized improvement costs. So the tenant pays $1 million in improvements to make the space what it wants. And however many years in, you pay whatever the difference is over a certain percentage. So this provision generally has some sort of a penalty associated with it, as well as the exclusive use clause occasionally. And, you know, that's also something to keep in mind.
Yeah, so I think if we're looking, it says a failed co-tenancy is, well, just page 3.
Yeah.
Less than 50%. Yeah, so I think that's really interesting, because that's where we get the mix of legal advice of the lawyer can stand there and say, well, this isn't a takings under the 14th Amendment because they still have the ability to provide to-go delivery food, and so it's not dark. And in the lease, they could say, we don't care. We're going to define open and operating as being able to serve patrons in and out. You know, they probably didn't foresee percentage requirements, but they easily could have said, no, we're not counting delivery. We want foot traffic. So you have to be able to serve people inside your restaurant. No percent, you know, unfortunately, no percentages, but that's probably how they would have defined it if they went that next step to define what occupancy or open for business means. I think the legal matters less. It's really a business negotiation where if a shopping center has a lot of stores closed, they got to go, you know, and depends how hard the anchor is going to push. But it's just a business discussion of, are you going to push this issue if there's nothing at fault of the landlord? Because realistically, what I would say as a landlord or landlord's attorney, okay, what do you want us to do? We could kick out these tenants for not opening up their pizza store. But who are we going to replace it with? Another liquor store? Are we going to replace it with a like a Walgreens? Like, it's just not going to happen. They're going to say, we have a list of 13 essential businesses. You're telling us that you want us to kick them out and replace the tenants with one of these 13, which we already have 2 out of the 13,
So, I mean, and even in this provision, the way it's drafted, there's kind of the percentage, then there's the amount of time, then there's actually specific tenants. So you see the anchor tenant definition, the junior anchor definition. So the way I generally think about this is if you have a grocery store and you have a large sporting goods store, you have a Dick's Sporting Goods. If you're bringing in a Giant, if you're bringing in a Harris Teeter, whatever it is, that tenant will most likely want Dick's Sporting Goods to be in operation for them to come in. So if Dick's is already open and operating in the shopping center itself, and you're negotiating a lease with Giant, you're negotiating a lease with Harris Teeter, they may have a co-tenancy provision that includes just Dick's Sporting Goods, saying Dick's Sporting Goods has to be open and operating as one prong of the co-tenancy provision. So again, there's a lot of different nuances to it, and most tenants have an idea on the other tenants that they want operating, and also depends on the shopping center, obviously, because not every shopping center has a junior anchor, a TJ Maxx, or a Ross, whatever it is. But generally speaking, an anchor tenant will want that junior anchor to be open and operating as well.
It's an incredibly complex negotiation or reactionary process. I'm sure that most of these decisions, they're either conducted by property management, advising the owners. It can get really complex and burn through a lot of legal billable hours in a hurry if you're trying to figure out where are we in terms of where do we stand on these clauses with multiple co-tenancies. It's not for the faint of heart. I think if this happens, the tenants, obviously they're going to come in with their legal and say, we think it's justified based on this, and they're going to be trying to ask for discounts. You as a landlord or property manager, you're gonna have to decide, how do we interpret it, and how do we respond to them with what we think our legal position is? And then, that's how I usually think of it, is legal A, legal opinion B, and then business people will they're closer in the middle in trying to work things out. Let's real briefly kind of touch on operating expenses. What's different about an anchor tenant when they're negotiating operating expenses than just a regular retail lease?
I mean, frankly, the stakes are larger. I would say that this provision particularly, I think most, even smaller tenants are attuned to, because this is rent. This is payments going to the landlord for the ability to operate within a space. So I will say this isn't as much of a anchor specific provision, because a lot of smaller tenants will include anchor type provisions into the operating expenses. But what I will say is the negotiating of this provision with anchor tenants is much higher stakes, because they have more square footage, they have a higher percentage of the shopping center's square footage in general. And these types of the caps, the exclusions, the inclusions in operating expenses are just much more meaningful. So from that perspective, I think that's the biggest thing with operating expenses with respect to anchors.
Do you think that they push back more as a partner, like, we want this snow removal company, or the landlord needs to enter into like multi-year agreements, multi-site to get their costs down? Is it at that level, like where they're trying to influence vendors? Or
I guess that really depends on the landlord, depends on the relationship with the landlord. I mean, I don't see that as often, and that really depends on how the operating expenses are sliced up. So if you have an anchor tenant that wants to take care of their parking field, their building, and there is a natural break to do that, then the anchor tenant gets to contract with who they want. Right. And they may ask the landlord for who the landlord uses, but generally speaking, they can do what they want because they have economies of scale. So from that perspective, maybe, but generally speaking, if a landlord is managing a property and the anchor tenant is paying its proportionate share, usually the landlord will have their own contractors, and unless something goes wrong, the anchor tenant won't usually push on particular contract.
The last kind of major difference that we have is continuous operation. And, educate me on this, because it's definitely something that isn't as big of a deal. I mean, definitely we talk about it on the normal retail, but sounds like it's one of the top 4 critical differences in anchor leasing.
It's definitely important to take a look at and understand what the certain provisions mean. And generally speaking, a large anchor tenant will only obligate themselves to open up fully fixtured, stocked, and staffed for 1 day. And for obvious reasons, as a landlord, you don't want that. You signed a 10-year lease, you signed a 20-year lease, you signed a 5-year lease, whatever it is. With Dick's Sporting Goods, you want Dick's Sporting Goods to be open and to drive traffic. But generally speaking, whether it's Dick's Sporting Goods, whether it's a whether it's a grocery user, whether it's a fitness user, if they're big tenants and they're anchor tenants, they don't want to obligate themselves to operate every single day, subject to holidays, subject to whatever. They want to open up for 1 day. And for all intents and purposes, they're incentivized to open up every day. They have to pay their rent. They want to drive sales. If they're a publicly traded company, they want to increase shareholder value. So, while the provision is scary for landlords, practically speaking, unless they're not making money, unless there's a very significant issue with the tenant itself, they're going to operate. But there is that, again, probably slight risk that there may be an issue and they may go dark. And which is why, from a landlord perspective, you want to add some sort of a recapture provision, which allows you, in the event the tenant goes dark and they don't operate for 30, 60, 90 days, whatever the negotiated provision is, you have the ability to go recapture that space.
I really appreciate you sharing this information. At a minimum, I think this has been a great conversation to understand what are you getting into as an investor, as even at the fund level of looking at entering this space, because it truly is a fundamental shift from, you could own 20 or 30 run-of-the-mill shopping centers, with equal tenants and never come across a tenant with this much power. So it's a great eye-opening experience to say, look, you really need your ducks in a row. You need to have your lawyer on speed dial. You need to have your broker on speed dial to say, who are my tenants? What's this mix going to look like? And plan things out for the next lease up and operations if you're going to sell. So it's definitely a special asset class. We've hit the key critical points. Download the form, read the article, familiarize yourself. If you have any questions, reach out to Tim or myself. He's the expert. Yeah, other than that, thanks for joining. And
sounds good. Thanks for having me, Ron. Enjoyed it.